Good evening, folks. It looks like the government is heading for a shutdown here this week, and unless the Democrats and the Republicans and the president can reach an agreement to extend the government and fund the government, we are heading to a shutdown. And what does a shutdown mean for us as immigration attorneys and for you as a person who relies on visa approvals is our topic for discussion today. I'm Sam Shihab with the law firm of Shihab Burke, and with me,
Brian Burke from Shihab Burke.
So this is not the first time we are faced with government shutdown, and this is not the first time the government, in fact, did shut down. We've dealt with that before.
Back in 2018, I think, was the most recent one, right?
And they talk about shutdown just about every year.
Sure.
And they continue to talk, and then
we've braced for this, and sometimes you get a continuing funding agreement that eventually gets replaced by a proper agreement and an extension essentially. Yeah.
Odds maker as of this morning had it at 70% the likelihood of shutdown, and I think if you're following the news closely as of about 30 minutes ago, probably these odds went up a few points.
Yeah, I'm tempted. I'm not going to bore everybody by Googling again, but yeah, there was just literally, I think it was a meeting, I think it was at the White House, where J.D. Vance came out of it saying, expect the government shutdown, essentially.
And sometime they reach an agreement at 11:50 p.m., 10 minutes before the government shutdown, to extend for 2 weeks to talk more, whatever.
Sure. Yeah.
We're going to not talk about the politics.
Politics will work themselves out one way or another without our involvement or opinion on it.
Exactly, and we don't control it.
Sure.
At least I don't control it. I don't know about you.
Announcement, everybody! I do in fact control all of politics. I'm the seat of power right here, Sam. You're so close to it.
Yes.
Yeah.
Sure, Brian. Sure. All right. So, what does it mean to you and to us as immigration lawyers if there's a government shutdown? We obviously are more interested in what's going to happen to the U.S. Department of Homeland Security, what's going to happen to the U.S. Department of Labor, and what's going to happen to the U.S. Department of State for the consulate when there is a government shutdown. Let's start with the easy ones first.
Sure.
USCIS are funded by your filing fees. And therefore, they, on the face of it, would think that it's no impact. However,
yeah, there are some parts of USCIS that are not funded by this. So E-Verify, EB-5, and some of the J1s are not going to be funded, and those services might be suspended or slowed down, or something along those lines.
So the EB-5 that's taking 3 to 4 years to process now is going to take another 1 month.
That's what that's yeah.
Sure.
Yeah.
But H-1B, if you have an H-1B pending and the LCA is certified and mailed and it's in the pipeline, how is that going to be impacted? Does that impact this application?
No. USCIS is going to keep on doing what USCIS does whenever they do it on the schedules they normally do it, generally speaking.
Those guys, salaries will continue.
You keep on paying them fees, they're going to keep on doing the work for you.
Yes. And obviously they're well paid, and I-45 takes about an hour to process.
Increasingly well paid as the government filing fees go up and up and up.
If there's an adjustment of status, how about adjustment status and visa bulletin approvability? Now, if the number is allocated, they can issue that green card. There's not a problem.
Yeah, no problem.
But the State Department, on the other hand, has a bigger problem because some of the State Department functions will slow down worldwide, and some of it might not. I mean, visa interviews will definitely slow down.
Yeah, and that's not good because we're always sort of already expecting that to be happening, anyway. Unpleasant stuff, for sure.
Mean, they're going to operate in a reduced capacity.
Yep.
Obviously, urgent matters and those that
diplomats, humanitarian, expedited cases. Those are the things I'm not going to worry too hard about. But honestly, those are relatively rare cases.
But interviews is going to take longer. These are not 100% funded by the fees, and therefore will be impacted. So if you're planning on an interview at the U.S. consulate for a stamp and the government shutdown, expect delays.
Yeah, I mean, so even if you have your interview, they do background checks and that sort of thing. There's all sorts of parts that they don't give us exact breakdowns of how the Department of State works, but expect things to be slower is the bottom line.
And that's the thing about all the immigration processes. It is a intertwined, complex process, especially in the U.S., where multiple agencies are involved, and if one piece, like for example, we're talking about adjustment of status, but adjustment of status has a background check component. Yeah. So the background check component are dead. Yeah. So if the background component has been cleared for you, then that continues. If the background component is not complete, your case will not move without that background component.
Yeah.
So, all right, moving on to the U.S. Department of State. U.S. Department of State, they handled the PERM labor certification.
Labor.
U.S. Department of Labor, thank you. Yeah. They handled the PERM labor certification, and they handled the labor condition application, and the investigation
into wage and hour violations through H-1Bs or that sort of thing. Yeah.
Yes. Yeah. So that is gone. That is not going to happen.
Yeah. I mean, for those who aren't aware, there's most of what we do with the Department of Labor, aside from those extra fun things like investigations, they goes through this portal called FLAG, Foreign Labor, I can't remember the full acronym, but it's an online portal from the Department of Labor where you can file LCAs, you can file prevailing wages, file your PERM cases. And when a government shutdown occurs, basically that beautiful, nice government website, instead of getting that, you get a sort of, single line on there that says the website's unavailable due to a government shutdown, something along those lines. I can't remember exactly what it is. It's been a while, but
where things can start to hurt a little bit is the prevailing wage determination request. So how does that impact you? So to do a labor certification, we have to have a prevailing wage filed. Now it's taking anyways 5-6 months or more.
Yeah, like maybe down a little bit, but yeah, I expect they're not working on them in their absence, so those time frames are going to go up. What
significantly higher.
Related on the PERM front though, there's the PERM filings themselves. PERMs have filing windows that are attached to how long your prevailing wage is valid for and how long your recruitment is valid for. And if there's a PERM case that has a filing window that only manifests during a government shutdown, you have a problem there, which is probably going to involve, paper filing of a PERM case, which, to quote the chorus, greatly increases your chance of an audit and is unpleasant on several different levels.
And also filing a PERM labor certification is the means by which your H-1B is extended beyond 6 years. Yeah. So if you're running out of H-1B time and you need that PERM to be filed, so you can get more H-1B time, whether it's the 1-year rule or it's the indefinite rule based on an I-140 approval after the PERM is certified, those will all be pushed back because the prevailing wage is delayed, because the PERM labor certification is not filed, by the duration of the shutdown, plus because you would think that if there's a 30-day delay let's say the government shut down 35 days. Yeah.
35 delay.
All of a sudden, the prevailing wage the prevailing wage is backed up by 90 days or something.
Yeah. Well, you would hope there would only be a 35-day shutdown, a 35-day delay, but there's knuckle cracking and coffee drinking and get back to working that people have to do after a shutdown,
getting the computers up and running again, getting the system up and running.
Get back into the rhythm of your job from that 30-day, not a vacation, definitely not. Sorry to those folks who get furloughed during that time for sure.
But many of these shutdowns work themselves out at the 11th hour. I don't think anybody benefits from that. Probably the Democrats and the Republicans and the president can all get together and get that resolved. Hopefully we don't have a government
I don't think anybody really wants to. I mean, there's blame to be. There's the problem with the government shutdown is nobody wants to take the blame, and the best way to avoid that, there's people who are always trying to allocate blame for this one that hasn't yet to occur. And I think everybody would agree the best way to avoid getting blamed is to make sure that shutdown doesn't happen.
It's all about politics, and what's in the best interest of the people is the last thing considered. oftentimes when there's a government shutdown. It's about who is going to be politically more damaged by the shutdown. When the Democrats and the Republicans do their own polling and analysis, and they find that they're maybe equally damaged, they equally come to a resolution. And then they say, okay, let's not shut down because we're going to get hurt. We're not. But if the Republicans are more damaged, then the Democrats are less likely to agree, and vice versa.
I mean,
which is unfortunate.
Yeah, as we're preparing for this, like there's half of the news articles are about the substance of like what the negotiations are about, and half of the news articles about here's what people are saying, trying to shift the blame to the other side. You know, who controls what, or who is being crazy and you know, unreasonable. Things like that.
Border crossing will not be impacted. These are important job profile that are not impacted by government shutdown regardless. So airports will run as usual. Border crossing will run as usual. No impact whatsoever. So that's really the rundown. And also, it is likely that we are going to have probably an extension. And there's really, you know, the only question I had, what can they do? What can they prepare for? What do you tell people to do if there's a government shutdown? I would definitely further recommend, as I have recommended before and as you recommend, not to leave the country right now, especially if you need stamping. If you have an H-1B pending, most likely not impacted. There's really not much you can do except sit down and watch the show.
Yes, the slow-moving train collision that is this thing is. Again, we're talking about this because it's all the news seems to point to it being increasingly likely. But again, this can be rendered moot in about 24 hours and some change when that deadline hits.
We switch gears and talk about Q&As. This is the time when you can ask us questions. You have the opportunity to ask us questions on YouTube Live. If you don't want these questions to be associated with your handle because of the increased scrutiny of social media, we have immigrationquestions.us. We own this website, and that website will allow you to submit questions to us live now or during the week, and we will take those questions as they come. Either way, we're going to try to answer as many questions as we can, either live here or through immigrationquestions.us.
Yes.
Take the first one from the website. It's been submitted by a gentleman here. Or?
We have it. I have them all pre-queued up here, and we're just going to get it up there. So I've pared some of these things down just because we have limited space here in which to put these questions. But my employer-sponsored EB-1 I-140 petition is approved. Can I change jobs now and still be eligible to file for adjustment of status for my 45 based upon this approval?
Well, the I-140 petition being approved, and now I'm still can I change job now and still be eligible for it? Of course not.
I'm going to give you a different answer on that.
Okay.
EB-1A.
Sure.
Self-sponsored.
Oh, it's a self-sponsored EB-1A.
Yeah.
Okay. Well, but he says my employer-sponsored EB-1A. So
but an EB-1A is not sponsored by your employer, though.
Correct. Yeah. Well, employer can be either way. It can be both. But to support your position, an EB-1A is generally self-sponsored. But if the EB-1A is 100% tied to the employer, but I think but I will agree with you that if it's a self-sponsored,
I see you're saying it's Oh, well, go ahead and finish that.
Yeah. So if the employer filed it, and not the employee filed it, like let's say Intel, it's specific to them. The work is done, etc. However, Brian, I think I'll have to lean. I can make a strong argument that you can move on, same or similar.
Devil's in the
no job offer is not required.
Yeah, devil's in the details of this case. So, but I'm going to maybe pick up the thread. It's basically if you have a area of extraordinary ability that's so inherently tied to what you're doing right now with your current employer, I would say you might have a problem because that's it. If it's so tied to your current employer that they can't imagine you elsewhere, they could say, well, gee golly gosh. Maybe it's not a same or similar occupation, but maybe you're not. They could ask the question: are you really intending to immigrate in that occupation? If you left the absolute best way to flex your extraordinary ability, you know? Yeah.
I mean, if you're doing AI,
Yeah.
and you have an AI AB1A, and then you move to a different employer and you're doing AI, absolutely.
Sure, yeah.
You can continue to file your I-45, and who cares, because it's EB1A.
Yeah.
But if you are opening a grocery store and filing an I-45, and you're not doing then that could be a problem.
Yeah, yeah. I mean, devil's in the details on that one. But again, EB1A is, you know.
Yes.
Yeah.
Yes. That's a good one.
Yeah.
Got us disagreeing.
Yeah, I always appreciate one of those.
Yeah.
So again, I've pared these things down a little bit to make them a little bit easier to get up on the screen here because we have limited space. But here we are. Had an India trip while AP renewal was pending. My previous AP validity expired while I was in India, so I used existing H-1B stamp and returned back to New Jersey. Now the pending AP was approved. Is my AP good for travel now?
Yes. You say no.
I'd say, well, is that AP not one that was issued contrary to policy?
He had one pending.
But
he had one approved. I had an India trip while my AP renewal was pending.
But I had an AP that expired whilst I was outside the United States.
My previous AP validity expired while I was in India.
Yeah.
So I used the existing. So yeah, that's a good question. I don't think there's any policy that's
exactly where my brain is going. I mean,
but there was an AP file, timely filed, while the other AP is valid while he was in the U.S.
Yeah.
And the fact that his AP expired while he's outside the U.S., does that render the subsequent AP invalid? I don't think USCIS thinks so because they issued it.
Yeah, so they do have the means to obviously raise your hand if you've got an RFE that says, you know, hey, we're working on your AP. We see you traveled outside the country. What's going on there? I mean, they have the means to find out about this.
Well, let me ask you this question: is there a written policy on when an AP is valid and when an AP is not valid? The answer is no.
Well, no, there is a policy. It's called when we approve your case. You know.
Yeah, but there's no written memorandum about when to file, when an AP is valid, when can we approve it, when can we not approve it. There isn't.
Yeah.
They haven't given us anything in writing.
Yeah.
All what we can see is their practice, what they have been doing.
Yeah. I don't think they ever added a policy page about that.
There's no policy on that.
Yeah.
So the fact that they've approved it, to me, I mean, here's what we know. What we know is an advanced parole. If you don't have one, if you file an advanced parole and you don't have one before, and you travel, that AP is invalid.
Agreed.
And we also know what we have. If you have an advanced parole and you fly outside and you file an extension or a new one, you leave and come back during the validity period of the first one, it's good. Now, what we have here is the following: a gap between the two while outside the U.S. and an approval.
Yep.
I'll take it.
Yeah.
Well, that's the way I look at it.
Well, here's how I feel good about this question. I think if they had an H-1B stamp, then I'd say my first and best advice is always try to come back on H-1B status. H-1B status has been very good to you. It's kept you lawful for all these years, and I'd recommend maintaining your H-1B status until your green card is in your hand.
Unless they ask you for $100,000 when you come back.
You know.
So the H-1B.
Yeah.
Well, I mean, if he has valid stamp on his passport, he's great. He's in great shape. But once that valid stamp on the passport expires, don't come on Don't go to the embassy because they want money from you.
Well, yeah, that's one thing. I mean, I'm waiting to do the next talk on the subject of H-1B and that $100,000 fee because I'm in the immigration lawyers groups and everybody's still going, well, we don't really know when it really applies yet. So there you are. Yeah.
Well, they're talking with India now, and they like each other, so we'll see.
Well, they also have to talk about the government shutdown. That's two conversations they have to have now.
Yes.
Let's see here. Here goes.
Booked an H-1B consular interview to renew my visa stamp before current H-1B visa stamp expires. In case the renewal is denied, can I still use current visa before it expires and return back to the U.S.? H-1B petition renewal approved in July 2025. Well, you're making an assumption.
I think you're going to make. I think you're going to answer this the same way in my head. Yeah.
You're making an assumption. If there is a denial of your H-1B stamp, there is a guaranteed revocation of the remaining time on your H-1B. If they get a hold of that H-1B passport, you know.
And just imagine the conversation. Oh, so you're denying my H-1B visa? Uh-huh. Is the visa that you left, my old visa in there, still good? Hold on one second. Get the stamp. You know.
Yeah. If they have denied your they're gonna say, "Can you give me your passport, please?" And then they can hand it to you and say it's revoked and your H-1B stamp is denied.
Yeah.
So yeah, unfortunately, if they don't believe you're entitled to an H-1B visa, they're gonna make sure you don't have one.
Yeah.
And that is done typically by invalidating the one that you have on the passport.
I'm gonna be a bit of a rainbow, a silver lining here. I am not, well, up until that $100,000 fee. Yeah. Anyway, haven't been hearing of much problems on the large scale with H-1B stamping lately. Basically, you go to the U.S., go to the consulate with a relatively fresh case. Maybe you get a inquiry at your client or with your employer, but not too many problems.
I wouldn't go to the consulate if I have 1 day left of validity of H-1B on my passport.
Sure. Yeah.
I would keep it until it expires and then apply for a new one.
Oh yeah. I mean, I would
never walk in with a valid H-1B in my passport and ask for.
I would try to plan. Oh, so I have two options. I can go back to the U.S. with my existing visa stamp, or I could get a fresh one whilst I'm here. I would go back to the U.S. with your existing visa stamp every time.
Yes.
That's still not guaranteed, but you take the
significantly less risky.
Yeah. If you're going to the consulate, you have to deal with the consulate, then customs. And if you're dealing with, my sincere apologies, my phone is ringing at me. That's it. Yeah. So yeah, I think we're on the same page now. This one, Sam, there's a whole lot of explanation along with this questions one and two. I think this is sort of a follow-up from one we had last week, but I'm going to take this question down here. And we'll put this person's question one on here as we read their whole sort of explanation.
I'll let you handle that.
All righty. So thanks for addressing my question during your last session. So this is from Wednesday. I'd like to clarify our case. I got a priority date of October 2013. The principal applicant is this person's husband, and she's I guess presuming she a derivative along with a son. Husband has an approved EB2 I-140 from 2014. EB3 filing in October 2020. Husband filed a new EB3 I-140 along with I-45 applications for all three of us. So October 2020, very common scenario, downgrade to EB3, file I-45s for everybody. EB3 I-140 was approved in August 2021, and our priority date was current. How we did not receive green cards at this time. I see. We were presuming that the husband last time, I think, got the approved I-45. Interfined EB2 in June 2022, our priority being current under EB2, we interfiled. Oh, here it is. My husband received the green card under EB2 in August 2022. My son and I remain in pending adjustment of status. My son is now 19 years old. And to get to the questions.
So now,
yes, sir.
I wanted to give us a concise summary for everybody about this.
I'm not known for my conciseness, but here it is. It's my husband got an I-45 approved in the EB2 category, and that's really the facts that are important to me out there. My
husband got a green card.
Yes.
Under EB2.
Yep.
And me, the spouse,
and the child,
and my child
haven't.
Did not, and
still pending.
And then still pending because every individual in the employment base gets a number, visa number.
Yep.
And it appears to me that the last number was given to the husband, or maybe there was some deficiency in the adjustment application, or some sort, medical expired, medical did not find them, whatever.
They didn't have the opportunity to approve that while dates for visas were still available for them.
Visas retrogressed. Now I have a family separation scenario. I have an I-45 pending. Okay.
Yeah.
And that I-45 pending based. Now here's the question I have for you. How long can the I-45 can be legally pending? The husband now is not an immigrant anymore. He's not applying for a green card.
Yeah. I mean, Sam, I have a very fun way this ends up. He's been a permanent resident since 2022. 2027, this guy can be a U.S. citizen, file immediate relative petitions for them.
And that's very possible.
I know, it's crazy.
It's crazy, right?
Yeah. So, but to answer these questions, when the EB3 final action date becomes current again, can my son and I interfile back to EB3 based upon husband's previously approved EB3 I-140? I don't see how it's possible.
Well, so where I'm having difficulty, Brian.
Sure.
Okay, is there's no I-140 anymore.
It were attached to the husband he's immigrated. He's done. And I think I'm coming to the same conclusion as you.
And there's no I-140.
Yeah. He's a permanent resident.
How can there be an I-485?
Because they are this is pre-acquired family members. They're eligible for green cards. The rules are that you are allowed to bring anybody with you to the United States.
So what's the underlying basis of the I-485? Of the wife and the husband?
I don't know if this is considered following to join, or basically
derivative following to join, potentially, yes, following to join.
But the rules are that these family members are pre-existed.
They may not be following to join because it's a family context question. Following to join, but it's a derivative beneficiary.
The right terminology is escaping me, but
it's a derivative beneficiary to him, and clearly the switch in underlying basis occurs with the employment-based petitioner. And that employment,
he's locked in,
and he's forever locked in.
Yeah. That's the way it's literally written on his green card, the category in which he got it. You know, there's a category on there.
I agree 100%. Yeah. I'm trying to challenge that premise in any way I can.
Oh yeah, because I want to try to find hope for these people because of course I do. Of course I do.
Now he's a permanent resident, right?
Yeah.
And he would be what is the spouse of a U.S. citizen or spouse of a permanent resident application?
Oh, holy baloney!
Why not do that?
Yeah.
That should have been done last month.
Yeah. So, Sam, we're so deep in the reads here. I think we need to re-engage with our audience.
Yeah.
So, what we're seeing here is that your husband is a permanent resident. This person's husband is a permanent resident of the United States, and as a permanent resident of the United States, he can file I-130 petitions for his immediate, not immediate relatives, but
his wife, his wife and derivative,
his wife and child.
Yeah.
And you file I-130s
now
there, and the priority date won't be current.
In about a month or two, maybe?
Maybe, yeah.
But
no, you're waiting for final action dates because the dates for filing for EB, for F2A.
Then file an I-485, and you don't have to worry about it.
Well, yeah. I mean, the bottom line is, I guess what we're sitting here telling you is, you have another path to a green card through family immigration. We have no clue how long it's going to take for your EB2 date to come up, and we don't know how long it's going to take for your theoretical F2A category to come up.
But the sooner the better.
Yeah. The answer is, our sort of best immigration advice always is take all options you can to get immigration, and you stop until one of them manifests with a green card in your hand.
Yeah.
Yeah.
So file an I-130 petition and work with your attorney to file an I-45 when it becomes current. Now you have a second option for you and your child to be here in the U.S.
Yeah.
And whichever comes first, the family petition may come in before the green card.
Worst case scenario, your husband can be naturalized in August of 2027, which ain't that far off. Yeah.
And then you can file and you can upgrade that application to immediate relative and get a green card.
Yeah, and I mean, your son will still be 19 years old, still going to be under 21 at that point, I guess. Yeah. So sort of a related question to that. If we deal with my son's, and the answer is you can't change you can't change the categories, and thereby there's no CSPA question.
But the CSPA, let's pause.
Sure.
Let's pause for a second.
Oh shit! Excuse me, language. Yeah.
So under the Child Status Protection Act, the child is 19. He definitely benefits from an I-130 petition because the time when the I-130 petition is pending is time granted to the child.
And they will leave that I-130 petition pending for a while, that's for sure.
Yeah.
But this child is already, I mean, I have to go back on what we said a little bit, but this child, having had a current priority date, presumably, he has a CSPA analysis to be done under the EB2 petition.
Well, he has two CSPAs analysis. Yeah. One as a family applicant, and one as a employment base.
Yeah, and I guess the worst case scenario if one of them didn't work out in your favor, if you still have the other card, the other case.
100%. Yeah. Complicated.
Fun, unfun scenario. Interesting for us legally, for sure.
So here's the bottom line for this case.
Yeah.
What you need to do is you need to be proactive. And my recommendation is to file an I-130 petition. This I-130 petition may or may not be of value, but it could be extremely valuable. Who knows?
Yeah.
And then file, and then your son will have another CSPA calculation that can protect him under the family category. Yeah. This can be very helpful if in 2 years, 19, 20, 21, the child can be very close to 21 when the husband becomes a U.S. citizen.
Yeah.
Because that time will count and will protect him. So I would file an I-130 petition immediately. to protect you and give you a second protection. Let's take the next one here. We've taken too long for this one.
Yeah, it was a fun one, but one last final question here, right at 6:30. Perfect. So again, I had to condense this down a little bit to fit it on the screen here in the thing, but EB2 priority date, October 2014, applied for renewal of EAD and AP for spouse and myself, both approved on 9/5. Spouse got EAD card as well, but my case shows approval decision rendered and haven't received the EAD. DUI in 2012. Do you see any issues?
Well, it looks like it's approved.
Yeah, but they haven't printed the card and sent it to him in the mail.
I understand.
Yeah.
I understand.
Should he be concerned?
I mean, in this environment, you don't have the card in your hand. You should be concerned. Yes.
Sure.
Yes, you should be concerned. But I am a little bit comforted by the approval decision rendered. Do you think it's denied when you say approval decision rendered?
No, not at all.
Not at all. So to me, it's a matter of time. It's in September 5. This is not too long ago.
Yeah, I mean, it's the sort of thing where maybe you put in a service inquiry in the case saying, document not received,
But they wouldn't approve the wife if they have a problem with him. He is the principal petitioner.
Yeah, I guess, I mean, the only thing that worries me is, do you have an underlying problem with your I-485? And the answer is, well, they wouldn't approve your wife's EAD. Yeah, I'm where you are. They wouldn't approve your wife's EAD.
So I'm more comforted that this is just a matter of time, more so than denial. But obviously, we don't have a crystal ball. We don't know. But I'm just thinking that this is just waiting because
sometimes
legally
the machine
speaking,
moves slow.
single DUI would not render you a non-adjustable.
Yeah.
All right. So with that, it's 6:30. Thank you guys for taking the time talking to us. Hopefully the government doesn't shut